Just to get started, welcome to the NYU Law Forum. And today I'm Amy Adler, and I'm here with my colleague, Jeanne, and we're going to be talking about a new paper we've written that will be coming out soon in the NYU Law Review called Memes on Memes and the New Creativity. And I just wanted to say before we get into the subject that academics tend to dismiss meme culture and to think of it as some sort of abject Gen Z joke that everyone hopes will pass. Everyone meaning old academic people. That it's pathetic shards of pop culture. It's hard to understand what it means, but we really think meme culture is extremely important and worth paying attention to, and that's what we seek to do in this paper. And I will say that we came to the paper, we've been talking about memes for a long time together and actually individually. And what we share, and we've done a previous paper together, what we share is an interest in pop culture and all kinds of culture, including pop culture and low culture, and in digital culture. So with that, I believe Jeannie's gonna start us off.
Yeah, we decided to do something a little bit less traditional while we were working on this project on memes, because we thought, what's the fun of talking about memes without using them? And so we decided to use memes to reflect back on meme culture and how it's affecting or could affect copyright law, creativity, and all other sorts of things. So I think you'll see that as we walk through this discussion. And but let me start out by just giving some background sense on copyright laws. I think it will be relevant here. So copyright law has been around for a little over 300 years, dating back to England in the Statute of Anne, as you see on the left here. And, it really arose in the wake of the printing press. And I say that because, it's really important to recognize how technologies of dissemination and the different types of ways in which we communicate with one another really can affect and did affect the law here. And so, there was no need, no pressing need for something like copyright law before the printing press. It was so expensive and hard to copy things. And the printing press arose, and all of a sudden it became easier to copy. Not as easy as it is today, which is something we'll talk about. But for the first time, there arose a demand to protect authors and publishers from their works being copied, whereas beforehand, handwriting and copying a work was laborious and expensive, so it didn't really happen. And so copyright law arose in that space, and then it's had to contend with over time as new technologies of dissemination and new media come about. It's had to contend with how to deal with that. But I think, as you'll see from what we're showing here, that a lot of copyright law's premises are baked in from that early moment in time. And as we'll show today, we don't think everything necessarily corresponds to today's culture, particularly meme culture. So let me walk through some of this. It's I think a longstanding notion that copyright is going to be freely available for certain types of works. Copyright law generally covers original works of authorship that are fixed in a tangible medium of expression. And it protects them against being copied in certain ways. It gives the copyright owner exclusive rights, to reproduce a work, to distribute a work, to make derivative works. And one of the things that here's one important assumption, I'll say, on which copyright law is premised, and you hear this in the name, copyright law, And it's, baked and weaved throughout copyright law, that creating happens or should typically happen without copying. And you see this from copyright laws requirements for protection. You see this in copyright laws requirements for finding something infringing. In particular, just to say a little bit more, copyright protection is available to original works of authorship, as I said, and it's understood that a work can only be original if it's independently created. Okay, that already, just shows lays bare the hand of copyright law, that works shouldn't be copied. They could look like other works potentially, but they can't be copied. Copyright infringement can't be found unless a party has copied someone's copyrighted work. If they've independently created it, they're off the hook, they're fine. They haven't infringed. And obviously there are exceptions to all this. Just copying is not enough to create copyright infringement. A work also has to copy in a way that the law finds sufficiently compelling, that you've taken too much. Additionally, the law condones copying in certain contexts, most notably with the fair use doctrine, allowing people to copy. But the structure of copyright law itself just sets out a framework that copying is an exception, and work should be created without copying more generally. Scholars have obviously questioned that, because anyone who's steeped in any particular cultural context realizes that work builds on other work in all sorts of ways, whether it's visual art or music. And that's clearly recognized, but it's just really important to note that copyright law takes as a premise that creation should typically happen without copying. Now, this leads to the following economic and moral points that copyright law takes as fundamental, which is that it's bad. It's economically bad, it's morally bad to copy someone's protected work. And the reason for that is just like the premise of copyright law, particularly in the United States, there's this notion that we give copyright law as an incentive for people to create culturally valuable works. And if other people can freely copy them, that will undermine that incentive, right? And so therefore, it's seen that copying is harmful as an economic matter. It's also thought to be bad often as a moral matter. Copyists are often referred to as lazy. Why didn't you go create your own work? And it's also, sometimes even seen as a form of compelled speech, as a moral matter, right? If you're taking someone else's work and uttering it, you've somehow taken away their autonomy because you're speaking on their behalf. Okay, so that's something also that's baked into copyright law. And then following from that is the notion that the exclusive rights that copyright law confers on copyright holders are things that these copyright holders can exploit to make money, right? They can reproduce their work in copies and distribute them and sell them, and people will buy them, right? So whether it's books, music, movies, TV shows, the exclusive rights are put into copyright law as a way for creators directly to make money. Okay, so that's one set of assumptions that are baked into copyright law. But there are many more that are quite relevant here. And one is the critical distinction that copyright law makes between idea and expression. Copyright law emphasizes that expression is protected, but ideas are not. And Amy will get back to this and discuss this a number of times later as we're discussing the First Amendment aspects of this. But that's the basic reason why idea is not protected. Otherwise, the thought is that copyright law would just be too broad. It would allow someone to monopolize ideas because they happen to get there first with that idea. And we really want there to be many expressions of an idea. So we leave the ideas free. and we allow the expression to be protected. Judges, as notable as Learned Hand, have struggled mightily to differentiate idea from expression. Learned Hand even said it's nearly impossible to draw the boundary between them, but obviously copyright law thinks that that's possible to do because it can demarcate what's protected as expression and what's unprotected as idea. And so there's an assumption, therefore, baked into copyright law that expression and idea are distinct from one another. Another aspect that's really critical to copyright law, particularly contemporary copyright law, is the very long duration of copyright. And so the connection to this meme here is that copyright law, currently lasts typically for the lifetime of the author plus 70 years. That's really, really long. Okay, it's so long that when an author is creating a work, they may not even anticipate all the ways in which they might be able to exploit their copyright during their time. I mean, would someone, many decades ago have anticipated that their work would be distributed on the internet in the pre-internet era? Probably not. And so the notion is this ties into what copyright law is trying to accomplish, is trying to allow copyright owners, creators to, reap the benefits from the incentives that they've gotten for a sufficiently long time to get them to create in the first place. This assumption has been attacked more and more as copyright has grown longer. It's been attacked by notable figures, including Supreme Court Justice Breyer, although he's done that in dissents, not in majority opinions in the Supreme Court, saying that the economic life of most of these copyrighted works is short enough that this long duration benefits no one and hurts society. Scholars have made the same point. Empirical work has shown this to be true with regard to popular music. But the point is, copyright law lasts for a very long time. Okay, another assumption here is that copyright owners get to choose who can and cannot exploit their work when they're exploiting it in ways that fall within the exclusive rights. This comes about in a few different ways. One way is the copyright owner can choose who to license a work to, right? So they may decide, a book author may decide, I want a French translation of this work, and I would like this French author to do it. I'm going to negotiate with them and give them rights to do that because I really want them to do this and no one else. Or I would like this person to make the movie of my book, or I don't want anyone to make a movie out of my book, and no one should be able to do that. So that's one way in which copyright holders can control how their work is being used. So there's really a sense of them getting to choose who's exploiting their work. Obviously, if something falls within an exception to copyright law, like fair use, they don't have that control, but otherwise they do. And the other way it comes into play is they can decide who to go after for infringement. And they could decide to tolerate certain uses that they might think are infringing. For example, they may decide, we don't want to go after our consumers who are making fan fiction. That's just going to be bad. We think we might have a good case. Maybe, maybe not. That's another story. But, we don't want to go after them because that's not going to be a good look. But we will go after, someone who's made a commercial production that relies on the characters in our works. And so that's another way they get to choose who's able to use their works, by deciding who to pursue for infringement. Okay, and finally, I think this is finally on our copyright assumptions, is the centrality of authorship as an organizing principle of copyright. The author is deemed to be central. The author is the one who gets the initial copyright in a work, not the publisher, not the editor. It's the author who gets that. And therefore, the author is the one who could exploit the rights or decide to license the work or transfer rights in the work. And this is very much about, steeped in a very romantic notion that the author is this wonderful special genius who's well placed to create this work, and only they could do what they do. And so these are the people we ought to be encouraging to create in the first place. So the author's special under copyright law and gets the rights. Okay, so there are many more assumptions in copyright law, but these are ones that we think we're going to come back to as we're discussing memes. But first, let's turn to that. I'll turn things over to Amy to discuss memes.
We're going to talk about how memes upend these basic notions of copyright law. But before we do that, just a few slides to a few memes to talk about what memes are, a surprisingly hard question, and why they're important. And one thing you'll see as we talk just about this definition of memes, we'll see the centrality of copying to this category, and ultimately the critical role memes play in contemporary creativity, political discourse, First Amendment speech. So as I'd mentioned, it's actually really hard to define memes. The term goes back to, it was invented by scientist Richard Dawkins in a book he wrote called The Selfish Gene in 1976, in which he coined the term meme to stand for what he thought was a unit of cultural transmission. And in any event, since that time, memes have come to be inseparable from their digital, what we now understand them to occupy a digital context. And there are several key notions, I think, going back to Dawkins that are still worth thinking about here. And I should say, the term is being used in a really elastic way. Some people think about meme as just kind of meme culture is a synonym for digital culture. Memes can refer to sort of any viral sensation, online or offline. But we're using the term in a fairly narrow, but I think customary sense, a typical sense, which is illustrated by the memes you've seen so far in this paper, sort of visual images with, usually with captioning or mashed up with other images. And we recognize that that doesn't capture the whole field, but I think that's the common use of the term. Just a couple of aspects about memes that are worth noting. Dawkins used the term, he created it based on the word gene, and we'll see a way in which this kind of genetic agency that Dawkins thought about in terms of memes is still, and coming from genes, is still present. The other term that he used to create memes was the term mimeme, this Greek root, which has to do with copying. And so we'll see copying as central to the definition of memes, and visuality, at least in the way we're using it, as central. And as we'll ultimately discuss, if copyright law views at its core unauthorized copying as a threat to creativity, we're going to argue that memes as a paradigm of contemporary creativity owe their very existence to limitless, unauthorized viral copying of visual images. So what's next? I want to go back to where I started this talk, which is to say how people dismiss memes and don't take them seriously. Certainly academics dismiss memes and view them as at best, a passing fad that will allow us someday, when it passes, to return to what's serious and what matters in the world. But there are a number of reasons to take memes seriously and why we do. And one, just to begin with, is how extraordinarily popular memes are. And there's this story that in 2016, memes replaced Jesus as the most popular Google search term. So just on that level alone, it's worth taking them seriously. But again, we do see them as a paradigm of this copying culture that we're seeing, a visual culture that we're seeing. And because they make numerous contributions to society of the kind copyright purports to promote. And just a few words about that. So in general, a few slides to follow, just showing how memes contribute to creativity, overall newness in our culture, and also to free speech values. And one way, it's sort of obvious, is that this paradoxical way in which memes allow us to create new content by copying, illustrated in this slide. And the next one, I think, oh, was there a slide? Oh, I see, a slide with, yes, this slide. So this is another illustration of how memes contribute to creativity, and that is that they allow us to recontextualize old content. So this popular meme is actually based on a painting by the 18th century portraitist Joseph Ducreux. This painting, it's his self-portrait owned by the Louvre. And for reasons that I actually don't know, it's become a template for people to insert archaic reinterpretations of popular rap lyrics. And we chose this one because it's the opening line to Roy Orbison's Pretty Woman song, Pretty Woman Walking Down the Street. And that's, I guess, a fun one for us because it's referring to a landmark copyright case by the Supreme Court, the Pretty Woman case, Campbell v. Cuff Rose. I particularly love this meme. Another way that memes create new content is by combining existing memes to create something new, super meme mashups. The Twitter user who combined these memes supposedly and created them said, I have to quote her correctly, "These photos together is making me lose it." And it's now become a popular meme that I think most of us know called "Woman Yelling at Cat," but it's, you know, a clip from the Real Housewives of Beverly Hills, and I don't know, one of the many gazillions of cat pictures that the internet seems to revolve around. Another extremely valuable quality that we want to emphasize around memes is that they create an in-group connection, a sense of belonging or insiderness. They're very conversational in nature, and also to the extent that some of them you have to feel like you're a little bit in the know to understand them. It's helpful in informing identity. Another quality of memes that's worth emphasizing is that they're democratizing medium, and part of a participatory culture and an engaged culture. And part of this comes from the fact that memes are so easy to make. Just about anyone can make a meme, they're lo-fi. And this meme, I meant to say means of speech, not memes of speech, a means of speech that is extraordinarily accessible. And I think this, another meme that I love of Bernie Sanders and his silly mittens, and the memes that followed on it. Yeah, thank you for that. These different pictures. Is this sort of lo-fi, easy to make quality of memes, not highly produced, anyone can do it, and really characteristic of this, it's the democratizing medium of our collective digital present. So a word about memes in terms of First Amendment values. I hear it's sort of a complex and interesting story. As many First Amendment scholars have begun to notice, there's been a real shift in our information ecosystem because of, since the introduction of the internet. And while free speech used to assume that it was hard to get your speech out there, it was hard to get the access to a medium where people could hear you and to distribute your speech, we now live in a world that one scholar famously called, Tim Wu famously called, a new attention economy. And in this world, attention is what's scarce and speech is really cheap. So as the internet has dramatically reduced the costs of producing and disseminating works, we're now drowning in information. And how does anybody get heard in this world of information overload? And I think memes are, in this sense, perfect modes of expression for speakers in this attention economy, because they're visual, and this is more generally a shift to a visual economy, which the Supreme Court long ago talked about visual images as a shortcut from mind to mind, and they're kind of a hack that helps you get attention and rise to the top of this pool of speech in which we're drowning. They're catchy and so forth. But it is worth noting, and I think important, that part of this power of memes to get your attention, to kind of get other people to engage with you and reproduce what you're saying, and to rise to the top of this pool, this power can also be a danger in memes. And certainly memes are not inherently good or bad as a mode of communication, but it's inescapable that in recent years, memes have been leveraged by extremist groups and foreign governments to spread propaganda, hate, and disinformation. And of course, memes are used for multiple reasons, but this is one aspect of memes. And we'll talk a little bit more about the Pepe the Frog meme as an example of this. And I think in this way, memes exemplify a change in the nature of online discourse itself. And this goes back again to this recharacterization of the internet that's happening in First Amendment scholarship. So it used to be thought that the internet was this, as one First Amendment scholar said, First Amendment manna from heaven. Now everybody gets to speak. But increasingly, scholars saw the threat to free speech values and to democracy, public discourse, and so on, posed by this explosion of speech. And the focus has been so far on primarily on platforms. But what's interesting about memes, and I think worth further conversation, is that I don't think scholars have talked about the shift in how speakers communicate with each other, and the change of individual speech acts that has also occurred in this shift, in addition to this dramatic shift in the power of platforms.
Okay, so let me take over a little bit and talk about how copyright law has come into play with regard to memes so far. As you'll see, it's come into play quite sparsely. It's very rare that copyright claims have been asserted, but we think the types of copyright claims that have and have not been asserted are instructive to thinking what could be down the road here. So again, litigation, not very common, but it has happened, to some extent. And I'll show you some examples of where it's happened. I categorize them mostly into two buckets. The first is when some entity commercially uses a meme, often a meme that's very popular, and the copyright owner goes after that commercial user, but not everyone else. Right, so here's an example with Keyboard Cat, which was a famous meme, and Neon Cat, and they were used in the video game Scribblenauts. They each sued for copyright infringement and ended up settling, but they're not going around and suing everyone who's sharing videos of Keyboard Cat or putting Neon Cat into their website or whatnot. Another example of this comes from one of the most famous memes, Grumpy Cat. So Grumpy Cat, the owner of the cat was licensing Grumpy Cat's image to use in certain commercial settings. And here went after the makers of Grumpy Cat various coffee products for exceeding the scope of a license. And the lawsuit was grounded in copyright infringement. Here's another example from a very popular meme, Success Kid. Success Kid was licensed to be used on various products and ads, but here someone went ahead and, without asking, put Success Kid on their fireworks. And so the mom who had taken the photograph and asserted herself as the copyright holder here, went after them saying, this is not an age appropriate product. We're only licensing this out to age appropriate products. Now here, Amy had mentioned Pepe the Frog, and here's the first time he becomes relevant. This is the second category in which copyright holders in memes have gone after people for copying their memes. And that's for uses they find to be politically undesirable. And so here you have this comic book creator, Matt Fury, created Pepe the Frog. Pepe the Frog was copied a lot, but at some point it started to be used by the alt-right to signify their movement. Alex Jones and InfoWars put it in a poster, as you see here on the right, that they called Make America Great Again, that they were selling for $17.76. Matt Fury, after letting everyone be and copy all along, sued for this, saying that he found this use to be so undesirable, he wanted to assert his copyright in the context and take Pepe the Frog back. Another example of this involves Success Kid again. The mom of Success Kid went after then Congressman Steve King for using the meme as part of his fundraising. Same reason. She said, I find him to be a vile politician. I don't want him using this meme. So that's where most of the actions happen. But interestingly, and we'll come back to this to discuss it, in very, very rare situations, it's asserted not against commercial users, not against politically undesirable uses from the view of the copyright owner, but against just like average people using memes in the regular way we usually use memes. And so here, Getty Images sued a German technology blog, or went after a German technology blog and asked for payment of $800 for using socially awkward penguin in a blog post. And the blog was reluctant to pay, but realized the cost was going to get out of hand unless it paid, instead of fighting back. They'd been asked by Getty Images to keep the terms of the settlement confidential, but they decided against that. They decided to publicize this, which is why we know about it. And they said, this is totally unacceptable. This could happen to you. This could happen to anyone. So I'm telling you about this. And here, there's no reason we should have to pay the copyright owner here. It's nothing that the photographer or Getty Images did that made this meme. The internet made this meme. It's not about the particular image. It's about there just being a penguin here that we could refer to as socially awkward. And so they said, let's use this penguin instead. And they gave a new image that they said everyone could use free of charge. No one's going to go after them to use that. Okay, so another way in which people have asserted copyright or copyright-like interests is they've gone after those who are using their memes without attribution. The most notorious example of this, excuse my language, involves Fuck Jerry, which is an advertising and media entity, also made very famous in the context of the failed Fire Festival. They had a reputation of taking memes, copying them, and sharing them from other people without attribution. And so a campaign began against them to get attribution. They called this hashtag #FuckJerry, to unfollow him, to call him out, to shame him for doing this. And this took off so successfully that he vowed, this whole entity vowed to change their practices and give credit and actually change things. So he lost followers in the process, which was a huge hit for him because he'd been making a lot of money off of sponsored content, but vowed to change his ways in the future. Finally, you also see some copyright licensing happening in this space. Again, rare, but it happens. One way this came to light was in the context of this famous meme that you see here on the left about this joke involving a text messaging someone that they didn't realize who it was. They're trying to figure it out, and it turns out to be their Uber driver. And T-Mobile uses it in an ad. They get called out for stealing a meme, but the meme creator and T-Mobile CEO both say we license this. So that's, another thing that's happening in the space. We'll come back to this later. I just, I'll turn things back to Amy so she could talk now a little bit about how memes, in light of what we're seeing, are upending some of these fundamental aspects of copyright law that I talked about earlier on.
Great, thanks. So I think, sorry, just let me, sorry about that. Yeah. So copyright envisions an author, as we've seen, who wants to fend off unauthorized copying. And meme creators, as we'll talk about, want just the opposite. They want their work to go viral, to be copied and remixed as much as possible, to lose control of the work. And there are numerous other ways that we can talk about, I think, that will show just what a dramatic misfit there is between copyright law's core assumptions, which Jeanne talked about earlier, and the core assumptions on which memes are built. So I mentioned this before, but I think the next slide, Jeanne, is just this basic premise of copyright law. In a way, its most basic premise is that without the incentive to authors to be able to ward off unauthorized copying of their work, they won't create in the first place. And so you have to give authors this limited monopoly on their work. That's what authors seek. And that's a condition of creativity. And what's striking about memes is that it's completely the opposite, that virality is the goal. The prospect of being copied is the incentive. Just to think about it another way, a work doesn't become a meme unless many, many people begin to copy it. So the incentives are turned upside down. The genre depends on copying, and nothing in copyright law can fathom or even describe this. And I will just say, one thing we talk about in the paper is how sort of savvy creators now are creating work with an eye to how it can be taken up and used as a meme. And one of my favorite examples of this is Drake, who is extremely savvy about creating videos in particular that will be memed. And his Hotline Bling video in particular is which became memed a million times, was designed and explicitly designed with that in mind, with the kind of green screen like blank backgrounds and the kind of doofy, simple dancing, just designed to be turned into GIFs and memes. But it's not just this desire to be copied, it's also this desire to have your work altered and changed in unforeseen ways. And again, this is so different from copyright law, which pictures a creator as sort of zealously guarding their work and making sure that only licensed users will guard the work and guard the work's integrity. And meme culture envisions an author who wants to lose control and open up a work for revisions, reuses, and misuses. I guess another slide here. Just quickly, there's this interesting aspect of memes that involves indirect monetization. And meme creators and sharers, to the extent there's a money incentive, one way memes make money for their creators, and a significant aspect of copyright law is assuming that economic incentives drive creativity. The money is not made from the initial work, but rather from the direction that the work creates, basically for the brand of the creator. Oh, I didn't say something about the previous one, just that in addition, this creation of value for the underlying work at all through copying is, again, defies copyright's basic premise.
So yeah, I could talk a little bit now about some of the other ways in which memes are undermining copyright law's fundamental assumptions. So because of what Amy was just speaking about, two things in particular, the ways in which underlying creators of copyrighted content, they get benefits from copying, as well as, and by the way, we see this because these content creators know about lots of their content being up online. The Real Housewives of Beverly Hills is a great example. There are lots of images posted from that on certain websites where you could like collect them from, and they think it's probably good for their ratings. I assume, they leave this alone, right? So they benefit from copying, plus this notion that you can indirectly monetize your works by getting all sorts of opportunities through the increased number of followers you get online, or getting opportunities in other ways based on that. It really hits on the fact that copyright law often makes a distinction between commercial and non-commercial activity. It does this most saliently in the context of deciding whether something's a fair use, by being more likely to condemn third-party uses that are commercial than non-commercial. The Supreme Court's drawn an inexplicable line between the two, as it is, by saying that a commercial use is anytime someone tries to benefit from a use without paying the customary price, whatever that means. That seems like almost everything to begin with. But this muddies the waters even further. Because what does it mean for a use to be commercial or non-commercial if you're not actually asking people to pay for it directly in any way, and any benefits you get are very indirect? So that, is creating these complications potentially as well. In addition, I talked beforehand about this line between idea and expression. Expression is protectable, idea is not. And I think, this mocking SpongeBob meme is a nice example here. Like, it's obviously expression, right? And copyright law in the traditional sense would say this picture is expression. It's a still from, an animated series, and that's protected expression. But memes turn things on their head by saying, aha, this is not only expression, it's also idea, because it now becomes a template for expressing things in a mocking tone. And so not only is it expression, but it's also an idea now, when you see what would otherwise be expression. So meme culture is distorting this line between idea and expression, not only by acknowledging that it's difficult to draw the line, but by saying that something can be both, which is something copyright law hasn't really contended with until this point. Another way in which copyright law is being upended in its fundamental assumptions by memes is the insanely fast pace at which memes are copied and spread. There are studies of this by mathematicians and sociologists about how fast memes spread. This is modeled. They, check this out. It really, things move so fast. I mean, it's not, that like we imagine in the pre-digital world, right, where everything moves a little bit slower, but memes can be shared by and seen by millions of people in a matter of hours, and copied and transformed in the ways that Amy was talking about. And so what that also means is that memes can become stale much quicker. So their lifespan, so to speak, can often be much shorter than traditional copyrightable works, because they're just getting passed around and transformed much quicker, and they run out. This doesn't happen to every meme. Some memes have lasting power, but others become stale fairly quickly in a matter of days, weeks, sometimes even hours. Amy, do you want to talk about how memes upend like selective enforcement?
Sorry, I'll say a few words about this. So I think earlier, Jeanne had talked about the way that the author gets to, or that typically copyright owners choose who they're going to sue, and only license to a few works, to a few users. And the default is that very few people or entities are able to have use of a copyrighted work. But the default is completely reversed with memes. And I should say that there is an exception in copyright law for shrink wrap licenses and Creative Commons licenses, where according to the terms of the license, basically everyone can use a meme. But there's this strange thing, rather a copyrighted work, but there's this strange thing in memes where, because of what we've seen as the decision by creators to basically allow everyone to use a meme, except for people that they disagree with, like, for example, the alt-right use of Pepe the Frog, or the use of, we've seen some politicians or some, we saw some other examples. We've seen some other examples of people suing just individual meme creator or meme users because they don't like the political view they're expressing. We see once again a real switch between copyright assumptions and the way memes work. Another basic switch that we see, and earlier Jeanne talked about the centrality of the author in copyright law. What we're seeing here is that the meme is really the central player, and the author is, if there is any author, is pushed to the side. And again, the traditional copyright view is so author focused. The work is entirely indebted to this romantic author, as Jeanne said earlier. The author is the mastermind. That's the word the Supreme Court used long ago to think about authorship. In the context of moral rights, a subset of copyright law involving visual art, the author is so intertwined with the work that the work of art is the artist's child. It embodies the author's spirit, as the Second Circuit said. But with memes, as with so many works in digital culture, what we see is what happens when the child basically grows up and leaves home. And the work now takes on a life of its own, much like Jeanne's, I think, and is meeting up with other memes and other aspects of pop culture and other authors. The work is kind of promiscuous. The work is getting into mishaps and new kinds of unions. The work is having children of its own. The work is constantly moving and changing in digital culture in a way that leaves this so-called author, whoever he or she was, in the dust.
Yeah, so let me talk a little bit now. Let's turn to what should happen in the law here. How should we think about this? First, let me just say that, like, obviously, I think you just heard, there are not that many asserted claims in the copyright context right now. But memes, as we're discussing them, seem like clearly copyrightable subject matter under traditional doctrine. Therefore, one might imagine that creators might assert copyright claims. And we could say, like, not much is happening in this space. Let's just leave things alone and let things just develop as they are. And that might be one appropriate response here. But we're raising the questions, more broadly about what happens in the law, because any norms not to sue here, except for these outliers of commercial entities and politically undesirable uses, for the most part, the alarm is raised that these norms can be very unstable. And we've seen this in other contexts already. We've seen this in the context of sampling, particularly in copyright, where sampling was mostly left alone, or entities like the Beastie Boys, who used hundreds of samples in their masterpiece album Paul's Boutique. They paid $250,000 in total as licenses for every single thing in that album. But there have been a handful of lawsuits about sampling, and some of which came out badly for the samplers. And now the risk-averse and conventional position is get a license or don't sample. And it's estimated that it would now cost $20 million for the Beastie Boys to have made Paul's Boutique, which would mean that it wouldn't be created. We've seen the shift in sampling. We see less of this like mashup style sampling that they did there, to like the song segment sampling where you hear just like one sample because you have to pay for it. So you'll pay for one and you're going to use the heart out of it, you know? And so just relying on people not suing might work out, but it also might not work out. And so that's why we're, you know, kind of raising the question about what to do here. So one possibility is we should say copyright should get out of this space, to invoke the highly memeable Drake here. You know, the notion would be that even though this is copyrightable material, maybe let's hope that things stay left alone as they have in other contexts, like potentially tattoos, which are, you know, probably copyrightable, but there are not many lawsuits involving them. But given this instability, we might want to go further and develop positive norms not to go after them. And, you know, let me just make clear, we're not saying that memes are great and ought to be preserved in all way, shape, and form. We're just kind of exploring that if one cares about the meme culture, then the second question is, how do you preserve it, right? And so we're exploring, what do you do if you want to be protective of this cultural space? And so you know, you could shame people who bring lawsuits as a possibility. That may work, may not work. That's shaming seems to be a very desirable mode of communication in our contemporary culture, as Amy and I have written in other work in the context of intellectual property as well. But it does raise some questions if we want to keep copyright out of the space and allow memes to flourish and be copied in the ways that we were talking about. So one way maybe to develop some more positive or, you know, norms here as alternatives is to think more seriously about attribution as something that might satisfy many meme creators to be attributed to when they're copied. It's something that generally authors like, you know, evidence has shown. You know, the concern with this is it becomes very impractical very quickly, given how much memes are copied and transformed. How are you going to attribute down the line, you know, if you've like transformed something that's been transformed like 5 times over and you don't know exactly who the author is? Time magazine itself, like a very established old school media organization, had problems about this with, if you remember the text with Hillary meme, from a few years back. They had a lot of worries about how to credit the various meme creators there. So it may be desirable, but becomes unwieldy very quickly. Another thing to think about is shortening copyright duration for memes. So tailor copyright law to memes. You know, they last too long, copyright law lasts too long for memes. It would be the argument, because they spread so quickly and they go stale so quickly. The economic life is potentially very short. Let's let people use them more freely, more soon. Another option is to narrow copyright scope in various ways. Some of the ones that, you know, we've seen proposed and we think might be the most interesting is to have a broadened sense of fair use in this context, be very conscientious that many memes are transformative in important ways, something that's often a touchstone of granting fair use claims. Another possibility is actually, you know, building on what Amy was saying about authorship becoming decentralized with memes, the memes becoming the central aspect, not the author, is to see that it's harder to find authorship and therefore copyright protection in memes as they spread. Maybe they even lose authorship. They start out with authorship and they lose it as the meme takes over. So there are many possibilities on that front, but those are just, you know, 2 I'll speak about here. And now I'll turn it back to Amy to talk about some of the First Amendment implications of memes.
Yeah, so thanks. I mean, I think we normally assume that, you know, the default is that everyone can use a meme, but what we've seen is that sometimes copyright holders are choosing to let everyone use a meme except for individuals with whom they disagree. And oh, was this, I can't remember if this is part of the section I'm talking about, but certainly, yeah, this worry, I guess, that hate groups are going to use for meme, like Pepe the Frog, and that worry that Matt Fury harbored. You know, this fear, everybody else is using the meme, why can't I? That I guess an argument could be made by certain groups who are disempowered. And of course, this can work either way. You know, it's not just hate groups. But it's this idea, if we think about memes as this democratizing medium, a platform for everyone so that everyone gets their own mini TED Talk, what does it mean from a First Amendment perspective when we have the selective enforcement and only a few viewpoints are deprived of using this common ground and this powerful method of communication? And so we talk about how this problem of forbidding a select few from using a meme that everyone else gets to use may present First Amendment worries. And there's this understanding in copyright law that it not only furthers First Amendment values, it's an engine of speech, but also that it doesn't violate the First Amendment. And this is a questionable assumption, I think, that it doesn't violate the First Amendment, even though it allows certain users to lock up speech, because there are exceptions or limitations on copyright law, primarily the idea expression limitation that Jeanne talked about earlier, but also the notion of fair use, that are First Amendment checks on copyright and satisfy First Amendment goals sufficiently that you can't challenge copyright from a First Amendment perspective. But what we're seeing here is that, particularly because I think First Amendment law in various places, there's a great case called Cohen v. California, where the court talks about the inextricability of a certain way of saying things with the message that you want to get out, that we can begin to worry whether this select enforcement problem with memes actually threatens that by excluding the meme from certain users. It might exclude a very powerful way of speaking to certain users, raising potential First Amendment issues. So I'll say about this. So ultimately, we want to talk about how much this matters. We've talked so far about memes defying copyright assumptions, but the question is, how significant is this departure really? Maybe memes are just this one-off thing. We don't have to worry so much. But we believe that memes are far from an exceptional case, and rather that memes are actually a prototype of a new type of creativity that really matters, and in a number of important ways that we'll detail. And I guess, first of all, the line between memes and more traditional modes of expression is actually not that clear at all. One particular way that both of us in our previous work have highlighted an aspect of creativity that memes may encapsulate, but certainly don't control the market on, is the role of copying in creativity. And maybe we'll take a look at the next slide. So we can start to re-envision this way in which copying has always been a building block of creativity through the lens of memes, and sort of thinking about certain maybe tropes or allusions in the history of art as one example of how these might be thought of as proto-memes. So what we see here is this recurring use, this recurring trope, maybe we could call it a meme throughout the history of art, of the reclining Venus. And we see throughout the Renaissance, Giorgione and Titian using that on the bottom slides, then Manet kind of coming back and referring to those works, but using that repetition and that reference to sort of break the meaning, because he's inserting this on the upper right, the prostitute in the role of the goddess Venus. That's Manet's famous Venus. I'm sorry, that's Manet's famous version of these lower Venuses. And then on the left, Mickalene Thomas, a contemporary artist, who again works with that tradition and works with the kind of copying, repetition, and change that's central to that tradition by inserting a Black woman in the place of the reclining white nude that has traditionally characterized the tradition. So this is at the Brooklyn Museum, this work, by the way. So just many ways in which we could start to see commonalities between these problems that memes present and problems more generally for traditional works.
Yeah, I mean, so I could probably just like speak briefly then about not just how memes are like traditional works in some ways, but how it's not just memes or the type of memes we've been talking about. This is a broader trend in cultural production right now that shares a lot of these elements that Amy and I have been talking about: the visual nature, the attention grabbing nature, you copy to be successful nature of memes, among other features. And I'll highlight a few examples here, although I think we could give many more. TikTok dance trends share a lot of this meme-like aspect. You want to be copied. You create something that's like a template that other people start to copy. It takes off, they transform it, etc. And notice also, I mean, it's like the visual memes we've been talking about, there's a lot about them that's adapted to being copied and being copied easily. The dances are more simple than the range of dances we can imagine. They focus on the part of the body that can be videotaped, so less focus on the legs often, more on the upper body. Another example of this is you might have seen the Ratatouille TikTok musical that started off with turning the Ratatouille movie into a musical with one song, and then people made more songs. People made multiple variations of songs. They imagined characters that are referred to but are not in the actual movie. They expanded on them and gave them roles. People made set design. People made a playbill, and this actually became a virtual musical that was professionally put on for charity during the pandemic. The sea shanties that you might have seen are another example. These are, 19th century music by sailors that a Scottish postal worker put up onto TikTok, and other people layered their songs on top of him, made other variations on it. Professional musicians like Andrew Lloyd Webber got involved and made versions of it as well. Olivia Rodrigo's driver's license was used as the background to many TikTok videos, acted out as well. We could go on, but it just, I think, shows you how much broader this production trend is than the memes that we've been focusing on until now. Amy, do you want to say a few last things about NFTs and how they fit here and what this means for creativity writ large?
Yeah, so even this new phenomenon for NFTs in which people are taking widely available images that anyone can copy and basically creating through the blockchain a quote unquote authentic original is sort of interesting to understand in terms of meme culture, because it can be seen, I think, as a reaction against some of these norms of memes that we're seeing. If memes are about sort of this endless flux, no one owns them, and it's constantly changing, it's always up for grab, then NFTs are this, I think, reaction against that that free-floating quality of memes, this attempt to privatize the image, to pin it down from a world of copies. Now all of a sudden we're going to pretend there's an authentic original. Someone can own it, which you can't really do with memes. So I think this can begin to explain the NFTs as a kind of craving for what meme culture has obliterated, or what meme culture's, what it represents has obliterated. And I think we'll end there, and shall we take some questions? Oh, you have something important to say, sorry.
Yeah, I mean, I could just wrap this up, as much as possible. I think there's a lot to say further here, but just to, make clear, there's traditional creativity that we think copyright law has and probably will continue to work well for. I mean, whether it's like blockbuster movies or pop music, but this new creativity, as we're referring to it, seems to defy so many aspects of copyright law that it needs different treatment. So we're not asking to upend all of copyright law, but we think it's important to recognize these different paths toward creativity. They're depicted here as different. We actually think they're going to intertwine much more than that in various ways. I think Olivia Rodrigo is a nice example of that. Her song went viral on TikTok as it was being used as the backdrop for other videos. That made it shoot up in streaming, made a lot of money in the traditional path, which feeds back onto the new creativity, etc. But now I will end here, and we'd love to hear your questions. So, we got some questions about fair use. Amy, I'm glad to speak to that, or you could speak to that as well, about, won't this all just be solved by fair use? I will say that it often will, but fair use is a very tricky beast to rely on. You never know what's going to happen. It's very context specific and requires a lot of expenditure if you want to fight that. So it's not very useful for an entire range of space to rely on more broadly, but you may have more to say.
No, I think that's, I couldn't agree more with that. It's who knows what will ever happen with fair use. It's super expensive to take a risk because you're going to end up in a very mired in fact-based litigation. But more generally, I think, although that may be an issue in terms of litigation around memes, what we're really seeing here is just, I think that the foundation of copyright law and theory is so mismatched with contemporary creativity that even if there's this legal doctrine, which we think is not that useful, but there to kind of protect this kind of creativity, fails to recognize that maybe copyright law just doesn't understand how people create. This very body of law meant to incentivize creativity is completely out of sync with what creativity is about on the ground right now in our culture, or one aspect of creativity, and to acknowledge Jeanne's slide that's still there.
Yeah, well, we have another question from recent graduate, Zach Bass, welcome back, about, are we aware of any meme licensing organizations that are being formed or have formed? I'm not, but that's exactly the sort of thing that, kind of prompted us to explore this before business models develop around this. Maybe it's a great idea to have some form of licensing organization, but I think, as Amy was just like underscoring, given all the mismatches between copyright law and memes, it would be worrisome in many ways if we care about memes. If we as a society decide we care about memes and keeping the space alive to, create, transform, evolve, without the interventions of licensing organizations, we may want to ask questions about that before they happen and think about putting memes in a different category. If we're not concerned about memes and their spread, then yeah, sure, go ahead despite the mismatch.
And I'll just add to that. Hi, Zach, student we both have had the pleasure of teaching, recent graduate. I think, the other issue is how to expand this beyond the realm of memes, because it's not just memes. What we're seeing really is that memes herald a new kind of creativity in which authorlessness and change and flux and sort of collective copying and reuse are fundamental to creativity beyond just the meme world. And so another reason why I think we want to draw attention and take seriously the phenomenon of memes.
So here's a fun question. Amy, I'll give this to you first. I suspect I know your answer. This is from 2L Adrian Chicharek. I hope I pronounced your name right. What are your favorite memes?
Well, I don't know. These are old, but I'm a complete sucker for a woman screaming at cat. I just can't get enough of that meme. And of course, I love all Drake Hotline Bling memes, even though they're also quite old. What about you?
Yeah, I think you'll find that I guess some of the memes we were drawn to appeared in some way or another in this article. That was part of the fun of doing this. I love the ones that just get so much transformation. I just think it's so fun to see how they can appear in different contexts. I mean, the Bernie Sanders, sitting on a chair one, it got old very fast. But boy, was it like crazy just to see all the scenarios in which one could put Bernie Sanders, from like dancing at a Hasidic Jewish wedding to like all the ones that you saw there. I'm also a sucker for all the like cute kid ones. Success Kid is great.
Oh.
That face can just be used in so many ways. Even the notion of referring it to as Success Kid, I feel like there's so many interpretations that one can put on that image. That Success Kid is not a success, is definitely not the only one. So I don't know. But I've also enjoyed it. I'll totally put in a plug for this. This was invaluable while working on this article, and you could go down a rabbit hole. The site Know Your Meme, if you're not already familiar with it, is like the Wikipedia plus for memes. You could learn a lot about the context of memes, how they're used, their origin story, et cetera, and totally fascinating. So definitely check that out when you're looking to waste time / learn. Well, I think we have like time for a couple more questions here. So memes and NFTs. Amy, do you want to expand on that? Because definitely memes are being sold as NFTs. And you talked a little bit about what you think the NFT demand is about.
Yeah, I think, we've talked about what NFTs represent in terms of meme culture. And it is, for example, Disaster Girl, another great meme. She recently sold her image as an NFT for something like $500,000. So I think it's this, some people are minting NFTs out of memes and making a lot of money. And it's this way of cashing in on what you can't. I think it's a way of cashing in, not that there's anything wrong with that, but cashing in on this otherwise uncontrollable mode of discourse or image.
Yeah, I mean, and I'll just add to that. I mean, there's been, a lot of chatter about this in the copyright space about what does this mean? Is it a way to protect the unprotectable? And I think most people think it's not a way to bring copyright back to the wild west of the internet, meaning of like controlling digital images, because what it is doing is still allowing you to freely copy. It's just trying to give you a way to be signified as the owner of having this unique particular copy. But with that said, I think we're out of time. It was really fun to discuss with you today. I wish we could have done this in person, and there will be more opportunities to discuss, particularly with our students that we get to see. So thank you so much for coming today.
Thanks, everybody.